Welcome to Plead the Facts, presented by KI Legal. On today's episode, I, Ralph Preite, a partner at KI Legal, will be joined by Greg Corbin, president of Bankruptcy and Restructuring Group at Rosewood Realty Group, to discuss everything that you need to know regarding 363 sales under the Bankruptcy Code. Hi, I'm Ralph Preite, partner with KI Legal. Today we'll be talking about 363 bankruptcy sales. I have with me today Greg Corbin, the president of the Bankruptcy and Restructuring Division of Rosewood Realty Group. Greg, good morning. Please tell us about yourself.
Good morning, Ralph. Thank you for having me. So I started my investment sales career back in 2006. In 2009, I got a call from an attorney friend of mine who knew that I sold buildings. And he asked me if I could do a building sale in Chapter 11 bankruptcy. Quickly Googled Chapter 11 and told him I could. Fast forward 2019, we had been doing a lot of bankruptcy sales, but it was still 75% bread and butter fee position with a side order of 25% bankruptcy. But again, in 18-19, we really pivoted because we saw the writing on the wall that there's going to be a lot more distress in the market. Right now we're doing about 90% plus of distressed assets, which not only includes the bankruptcies and foreclosures, we do restructurings, we do workouts, we do refi, we do recap, loan sales, everything that falls into that distressed asset niche for single asset real estate. Last year our company overall, we sold $2.2 billion worth of single asset real estate, and my team from 2020 to date has sold close to 100 buildings, distressed buildings, 77 of which were in bankruptcy, either under a Chapter 11 plan of reorganization or a Chapter 7 liquidation, typically with the trustee. And there's the background.
Terrific. Well, that's impressive. Thank you. But getting back to selling properties in bankruptcy, whether it's under a plan or under 363 of the Bankruptcy Code, generally, it's a structured and organized effort, which includes getting a broker, getting terms, finding an initial offeror that would serve as a stalking horse. Why don't you explain a little bit about that process to show that it's not really a fire sale, but a very methodical and sane procedure that hopes to extract as much value as possible from the property.
Right. So typically we get hired in a Chapter 11. It usually starts with the attorneys referring us to a borrower. We do the dog and pony for the borrower. There are probably some other brokers that are competing. When we get selected, we then move into all of the things that come along with it, the declaration and the retention agreement and the creditor and claims matrix, saying that we're unaffiliated, and that's par for the course. Once in a while we'll get a call from a trustee that says, oh, by the way, we've selected you as the broker, which is great because we don't have to do anything. They tell us that they already, they're about to file the paperwork, sign here, this is your fee, get going. And those
that's a Chapter 7 trustee?
Chapter 7. So they're typically the Chapter 7 trustee that's going to run the 363 liquidation versus the Chapter 11 plan of reorganization.
Right.
We love it when we get the trustee call. We know it's going to be quick. It's going to be a couple months. We're going to do the same marketing process, but it's going to lead to a much faster sale than a lot of these 11s that can turn into a convoluted 1 year, 2 year, in a very lengthy process.
Right. So to help explain that context of that Chapter 7 trustee versus Chapter 11, for our viewers who might not be familiar, 363 is a section of the Bankruptcy Code. It appears in Chapter 3 of the Bankruptcy Code. Chapter 11 and Chapter 7 are two other chapters of the Bankruptcy Code under which a bankruptcy petition can be filed. And if the petition is filed under Chapter 7, then a Chapter 7 trustee gets appointed who takes over control of the company that filed bankruptcy and all of its assets, specifically a piece of real estate if it owns a building, and liquidates the asset by marketing it through a broker, through a defined process to raise money, to sell it and raise money for creditors. And the trustee then distributes the creditor the cash to the creditors in order of priority. The mortgage holder gets paid first, then the junior mortgage holder gets paid second, and so forth. With Chapter 11, a piece of real estate that the Chapter 11 company or the company that files Chapter 11 owns could also be sold in bankruptcy. And instead of a trustee being appointed, management that was at the helm when the bankruptcy was filed continues, and hence the concept debtor in possession. Management is still in possession of the company's assets, and management tries to propose a plan which will often do more than what the trustee's concerned about, and hence take more time, like, yes, pay off the mortgage holders and try to pay something to creditors, but also try to extract some value for equity, the people or the companies that own the shares of the company that filed bankruptcy. And more often than not, there isn't enough equity to reach, or enough value to reach shareholders. So that's an example of why the Chapter 11 case might take much longer than a Chapter 7 sale. Chapter 7, you mentioned, could take 3 or 4 months and you're done. Mm-hmm. Chapter 11 could take 2 years.
Yes.
And that's a function of how much patience the bankruptcy judge might have, and really how much value there is in the property. So getting back to when you're appointed, you're selected. Your firm obviously has a reputation that precedes it, you in particular, or your firm in general. Yep. So when a Chapter 7 trustee is appointed to a case that has a piece of real estate that needs to be sold, they obviously know you. Do you find yourself in a situation, are the Chapter 7s the result of a case that started as Chapter 11 and got converted, or are they filed initially as Chapter 7 from the get-go? Is that a scenario you face?
Sure. So
often?
Most of the time it's from the get-go. They determine whether or not they want to run the 363, the 7, or an 11, which is really, it's under the plan of reorganization in quotes. Most of the time, everyone knows it's going to result in a sale, but it gives the debtor the opportunity to, quote, reorganize, which usually entails us looking for a joint venture partner, a source of equity, for a refi or recapitalization.
To keep the property and not to
keep
sell
the
it.
property. I would say 95% of borrowers we deal with, whether realistic or not, they want to and think that they're going to end up still involved in the property, whether it's keeping it or with some sort of joint venture, maybe even if it's a hope note or a flyer on the back end, they want to remain involved. And it's twofold. One is because they're married to the property,
right.
They've had a lot of emotional history. And two is if they lose the property, it's a lot bigger of a black stain on their reputation and career, versus even if it's a 1% chance on the back end, they can then save face by telling the investment community, I'm still a partner there, I'm still in the deal.
Right.
So they do want to stay in the deal to, in whatever parameter, but usually it ends up with a sale where they end up losing the property. They are always, think that their property by definition is worth more than the market thinks. So as you mentioned before, most of these deals, there is no equity left, and it comes to us because it's the last stage, in the process. Once in a while there is, and we'll make a sale, and there's full distributions to the creditors, the secured creditors, the unsecured creditors, the professionals. Everyone gets paid, but that's the anomaly. Most of the time it works out that they're negotiating X cents on the dollar for the unsecureds.
Do you find that, and maybe this is too broad of a question, but are you finding that lenders that have senior and junior positions, junior mortgages and senior mortgages on the properties that you're handling, are more inclined to work out a deal that provides creditors with, general unsecured creditors that have no mortgage, with some sort of distribution when the property's sold, or are they just hell-bent on maximizing value for their own claim and to get their own claim paid,
Right.
and they're not looking for some sort of consensual deal? Or is it a case-by-case basis?
It's a good question. Before I tackle that one, the other one, which just struck me, when it's not right off the bat determined, often there's a Chapter 11, which, as you know, plan confirmation could take quite some time, could take a year.
Mhm.
It's usually not, but it could. And so if it's running the course and people have deadlines, under the Chapter 11, you save a transfer tax, which is the main reason people like a Chapter 11, because it can be a considerable amount of money. It's 2.625%. So if you have a $50 million deal, it's a nice chunk of change, and it's worth, if you have anywhere between $500,000 to a couple $1 million of a transfer tax saving, people do everything they can to preserve that. However, oftentimes they will decide that it's better to get this done expeditiously, convert it to a 363 sale if deadlines are not met, or if the creditors, sometimes a creditor will come in and, file a claim last minute. They rear their head and say, I don't like what's going on, and I'm owed money, and then the borrower will have to kind of switch courses and say, let's run this to a 363 because this might take a year. So whereas we'd say the transfer tax, we've got real estate taxes accruing, we've got all these other fees, it's actually in our better economic interest to liquidate, not say the transfer tax, but at least get it done more quickly.
And figure out who's owed what and what priority after the sale.
Right.
Right. So, and that's an important point about 363 sales or bankruptcy sales in general. When a building has mortgages on it, the mortgages are filed, and they usually are in a certain priority. Like the oldest mortgage is senior, unless everyone agreed to make it senior with a contractual provision. But generally, you have senior mortgage and then junior mortgage and junior lien holders. And when a property is sold, it's sold free and clear of all those liens, so that the mortgages are no longer attaching to the property that the new owner has bought through a bankruptcy sale, and instead all those liens attach to the sale proceeds. And they attach constructively in the same order that they attached to the building. So if there's a dispute, if there's a late filed claim or a dispute as to who's senior and who's junior, instead of litigating that while taxes are being unpaid, while interest maybe at a default rate is accruing, and while maybe the market's deteriorating for that property, sell it, and then figure out who's, entitled to the money afterwards. And the money's held in trust. It's held in an IOLA account or an attorney's some escrow account, and then that's where either the horse trading occurs and settlements are made, or litigation occurs. But it's without the gun to your head of interest and fees and taxes accruing and being unpaid. So it helps cut off that liability. What's interesting though is you make the distinction between a 363 sale and a sale of real estate under a plan of reorganization. A 363 sale, if a company that files bankruptcy wants to sell its property under 363 of the Bankruptcy Code, all it needs to do is show the bankruptcy judge and creditors that it's a good business decision to sell it now. No voting is required. Creditors can object and say, no, it's not a good business decision to sell it now, and show why. Maybe creditors can come up with another buyer that would offer more money, but votes aren't needed. All you need is a bankruptcy judge that says it's a good idea or agrees that the sale is commercially reasonable and it satisfies the business judgment criteria of the management of that company that owns the real estate. Compare that to a Chapter 11, which takes longer. A Chapter 11 plan, which sells real estate under the plan, requires voting and confirmation and meeting certain standards that are set forth in the Bankruptcy Code. In fact, it's not 363 of the Bankruptcy Code that allows for sale of real estate under the plan. It's the plan confirmation provisions in Chapter 11 of the Bankruptcy Code. and that's 1123 of the Bankruptcy Code governs. So there, it's a longer process because you have to follow the whole plan confirmation scheme of the Bankruptcy Code. And creditors have a right, and it's democratized, so they can vote. They can vote in favor of the plan which sells, or they can vote against the plan that sells. And then you have to have enough votes and see if you can sell. So that could take a long time.
Right. So great synopsis. Something else to add is that sometimes we will do a consensual prepackaged or a pre-pack, which speeds up the timeline as well. So as opposed to getting the votes and gathering everything down the road, after the filing, if they can get it together prior, they can get the creditors on board, they can get, I believe it's 50% of the votes and 75%.
Number, right?
Yeah, number.
There's a formula that gives smaller creditors some
Yes.
sort of say by making them at least half of the creditors vote in favor. You're right, there is that formula.
So I got to look that up, but that's for you, for the lawyer. But I do know there's some sort of percent that needs to be done.
50% and 2/3.
Yes,
And,
2/3, right. Mm-hmm.
But if you can get all that done before you file bankruptcy,
Yes.
that's setting it up for a prepackaged Chapter 11, which you then file and you show the judge and the U.S. trustee, which is a division of the Department of Justice. Judge, we satisfied all the criteria of Chapter 11 plan confirmation requirements, including we got all the votes that are necessary. So let's not wait the 60 or 90 or 120 days for filing a plan and getting votes. Let us get the plan confirmed now. And that gets the company in and out of bankruptcy quickly. But those cases are usually where am I wrong, where the company intends to keep the property or tries, the prepackaged plan wants to have the company emerge from bankruptcy still owning the real estate, not selling it.
Right. So that's always the intent.
That's always the
Sometimes it
intent.
ends up that way, sometimes it doesn't, but that is, what the borrower usually wants going into that.
The borrower meaning equity that the company
Correct,
that owns the
correct.
building, right?
Yep. So when they do that, they're hoping that the market's going to go with them, that interest rates might go lower, the cap rates will compress, their building will be worth more. What happened the last few years, there were a lot of problems with various buildings that had started to have problems prior to COVID, and then obviously that got exacerbated due to rent strikes and people not being able to pay and vacancy rising, which lagged and carried through. Even up-to-date buildings are still getting cleaned up, but having had a period of 6 months, 12 months, 18 months with lower collections, a lot of borrowers that were terrified they were never going to collect rent again opted to keep the money, thinking this might be the only money I'm going to get for a while, and not pay the mortgage at all. So we had a lot of scenarios where we've got either the senior mortgage, the mezz, or both that haven't been paid in quite some time, and until a receiver gets appointed to start collecting rents at the property, the borrower is still able to keep collecting those rents, and it's very problematic because the bigger that number accrues, even if it's there's no equity and it's underwater, once the case settles, that there's a bigger deficiency judgment or a bigger claim for the lender to go after with the borrower, especially if there's personal guarantees, or if there's recourse, that number has now grown. So if this thing goes for another year or two, even though the borrower is technically collecting rents and pocketing that money without paying the debt service, that number, the delta between what is owed and what they've been collecting, is now much bigger, and that's what the bank is going to go after them. If it's a small amount and it's a little plus minus, I found that lenders have tend to forgive that and they won't pursue a deficiency judgment.
Right.
However, if the borrower is very pugilistic and has thrown monkey wrenches in
Yeah.
return, and they've filed TROs and they've changed venues and they've personally upset them,
Created bad
lenders
blood,
are
yeah.
lenders are people and they take it personally and they're
Right.
emotional, and a lot of times they will go after a borrower even if they realize that the claim is not likely to be collected on. They say, we're a big shop, we've got in-house counsel, we're just going to do it to make their life miserable. The attorney fees are much cheaper for us, and let them struggle. They were
Right.
not nice to us, and we're not going to be nice to them.
Or, the lender is regulated, the lender is a public institution of some kind that has to answer to different regulators and can't, and therefore isn't allowed to allow deficiency judgments to remain uncollected, and has to, per the regulations that govern them, whether it's FDIC or whatever, pursue those claims in order to meet whatever regulatory guidelines or requirements need to be satisfied. Who knows? But yeah, you're right. Being good to your lender is not a bad idea.
Right.
And causing trouble doesn't engender cooperation down the line, or even at the at the get-go. All right, that's very interesting. One aspect of Chapter 11 I'd like to point out, which while talking about 363 of the Bankruptcy Code, is the code provision right next to it, 362 of the Bankruptcy Code, which is the code provision behind why bankruptcies are filed. When a bankruptcy petition is filed, an injunction is issued by a federal court, United States Bankruptcy Court, and that injunction arises under Section 362 of the Bankruptcy Code. And what that injunction does is it stops all collection efforts, whether it's a foreclosure action or just a lawsuit on an unsecured debt, or actions to appoint a receiver to collect rents. All of those efforts are stayed by Section 362 of the Bankruptcy Code, and that provides for a breathing spell for the borrower, the equity, the owner of the building, in real estate examples, to now figure out what to do. If there isn't enough foresight to do a prepackaged bankruptcy, or if there isn't enough foresight to start working and planning, and they just let the mortgage go unpaid and a foreclosure action was commenced, and there's about to be a judgment of foreclosure entered, or a receiver appointed, and then a Chapter 11 petition is filed to stop that with Section 362 automatic stay. And then the borrower, the company in bankruptcy, can look at its options. Should I sell? Should it sell under 363? Is there a market? Is there has the building been marketed at all? Should we turn to Rosewood and say, help us find a buyer?
Yes, they should.
And see what investors you might be able to find, if there is some long-term upside that could be realized with capital. So maybe a plan of reorganization could be funded along those lines if you get real estate investors involved. So 362 of the Bankruptcy Code provides that, and I called it a breathing spell, a period of time to help assess the situation and figure out what to do, reorganize or sell, or throw in the towel and just convert to Chapter 7.
Right.
So that's part of the Bankruptcy 363 analysis.
And that typically happens at the 18th hour. We'll see the automatic stay, which is implemented
Yes.
by definition with the bankruptcy filing.
Right.
Usually happens the day before, and sometimes we've had it hours before we've gotten
The morning
notice.
of.
Yes,
the morning
Yes,
the morning
Correct.
of the foreclosure sale. Right.
Correct. So we get that a lot, and it's just, as you said, a measure which is a giant timeout. We need more, we need more time to figure this out, and a lot of times that's with the UCC foreclosure.
Right.
So
Oh,
we're
definitely.
hired a lot of times, prior to a bankruptcy, when the mezzanine lender is foreclosing on the interest or the LLC portion, not the real property through judicial foreclosure, but through a UCC foreclosure.
Which is much
typically
quicker.
Much quicker. It used to be 30
Non-judicial,
days.
yeah.
Yeah, we used to do these in 30 days at UCC. A lot of judges determined that was not commercially reasonable during COVID.
Mhm.
So people just protect themselves said 60 days, maybe even 90. Some of the more aggressive lenders said 45. But as long as it's defensible, that it's commercially reasonable, and the optics are there, that we went to market, and we had, we sent the 40,000 emails, and we've posted on every website, and we've done the social media, and we had 25 inspections.
And those are meaningful
It's-
optics. They're not just optics
Right.
for the sake of optics. They're real efforts undertaken by your
Correct.
team to market. Yeah, sure.
Correct.
I like the phrase you used, giant timeout,
Right.
to describe you. I'm going to borrow that. I'll footnote
Sure,
you.
sure.
I'm going to use
As long as there's a
it.
little asterisk there.
There you go. There you go.
But yeah, so I think, as you were saying, it's really a period where they can gather their thoughts. So and a lot of times we're working on a deal right now where there's a UCC on Friday. We've been doing everything in our power. We've been running parallel paths with the borrower who will hand back the deed to the mezzanine lender and give them X million dollars. We've been, yeah.
A sale of the deed to this mezzanine lender?
Well, it's not even a sale. They'd be giving the keys back and handing them a chunk of the cash collateral, which has been collected.
I see. The receivables, the rents that have been collected.
Correct. So the rents are sitting in a specific account as cash collateral, which they would hand over. They would give them, again, X million dollars and the keys and say, hey, now you're the borrower. You stepped into our shoes. You are now beholden to the senior secured. You guys work it out. You know, they have the contract, they've got the principal, they've got the contract rate, they've got their late fees, penalties, their default interest. So at that point, the mezzanine lender, either they've pre-baked the deal with the senior and they've said, look, you're at a ridiculous number. There's no equity here. If you knock off X% or the full, default interest, we're happy to step into the borrower's shoes. We'll do a reinstatement. We will operate and continue to be your borrower and we'll own the building. Another path, which we were working on simultaneously, was to have them pay off the mezz lender at a certain amount.
Mm-hmm.
They would keep the keys. They would then work something out with the senior lender to stay in possession of the building, which is what they wanted.
Right.
But again, it's a very dangerous path to either bid on the UCC on the membership interest at a foreclosure action, not knowing if the senior lender is going to play ball, especially if the equity is drained from the property.
Right. Yeah, well, you need to try to have some sort of communication going on
Right.
to get and you can serve in that regard to help, not back channel, but communicate with the senior lender.
Correct.
On behalf of the borrower and see what the temperature is for working out some kind of deal.
Mm-hmm.
So you generally have insight in that regard,
Right.
or you try to get that.
Correct.
Right. Speaking of insight, is there anything you can share regarding commercial real estate here and the status of borrowers, lenders, occupancy, with the backdrop of COVID and COVID hopefully, winding down and occupancies returning and the mayor of the city having workers return and encouraging, and JP Morgan encouraging or having its staff come and things along those lines. Is there any insight you have on that front?
All right. So
that's a multifaceted question.
That's a big one, and I'll dive into that. You mentioned something interesting about the back channeling, and we want to sort of present it as, hey, we're the quarterback. So we are doing that behind the scenes,
Mm-hmm.
which is we will be talking to the senior lender, we will be talking to the mezz. A lot of times the borrowers are even disorganized and there are multiple factions of borrower. So you've got a number of partners and they don't see eye to eye. Some want to file the 11.
With each other often.
They're all irritated, right? Everyone's irritated with everyone. So we come in and we try to tell everyone, look, drain the emotion out of it. I know it's been a long few-year process,
Right.
but let's all be the grown-up in the room and do the best, for the business decision versus the emotional decision. So by having a new voice step in, whereas a lot of the lenders don't even want to hear the borrower's voice because they've been over years not paying them, coming up with every excuse, again, filing the TROs, switching venues. They're very frustrated and a lot of bad blood. When we step in, we introduce ourselves and we're kind of a new voice of reason saying, look, we're going to bring the parties together. We're going to speak individually to everyone. Towards the end, hopefully we're going to have a meeting where it's face-to-face or a Zoom meeting where everyone can then agree on the last component. But we're doing a lot of the behind-the-scenes heavy lifting and legwork to try to get the workout or the restructuring so it doesn't have to go to the bankruptcy. Again, if we can't get that done the day before, they will file the 11. But it is a lot of that, kind of back channeling and, maneuvering and manipulating to try to get to a point where everyone's seeing eye to eye because we're just always smiling and saying, look, we're not your enemy. We're just trying to convey the message.
And get you paid.
Getting us paid is the most important part of it. That's the equation. So I guess tackling the next one, if you want to go one by one, you want to give me each of the ones and then I'll try to address them.
I look at buildings in Lower Manhattan and they're still empty. And are there any stats on whether or not those leases are being paid even though the workers are working remotely, or the space has been surrendered, or the lease terminated and there was no renewal? The real estate reaction, or the tenant reaction to COVID with the ability to work remotely, I think is going to have a long-term impact on occupancy and on values, and increased, I think it'll have increased bankruptcy filings for, or at least defaults on real estate loans and mortgages. So I was wondering if you saw that improving, or if that's still a big driver, or was it ever a driver?
Right. So I think Class A office is okay. It's not great, but it's in much better shape than B and C, which is, been, I guess, deemed by everybody obsolete. These things have not been renovated in quite some time. There's a lot of talk these days. I know the mayor and the city have been discussing having these office buildings being converted to residential.
Right.
Some of them are even becoming homeless shelters or public housing. If it is being converted to residential, they do want a big affordable component. The issue is these office buildings were built for office. So the light and the air factor, the cores of the building, everything needs to be restructured.
Plumbing,
Obviously, it's
right.
plumbing, right? It's not cost efficient to do it, and it still does not leave the appropriate or necessary amount of light and air. So whereas it sounds great conceptually, convert the building, it's going to be a lot harder than people have been throwing around. So I think that's a wait and see. Office obviously is, we do it occasionally. It's not our specialty. We really focus on the multifamily, the mixed use, the development side, occasionally hotels. I think hotel is going to be there's going to be a large amount of hotels coming into play. We were just hired on the Wagner Hotel, which was previously the Ritz-Carlton. That's been in trouble for quite some time. They have a ground lease with Battery Park City Authority, so it's that's an hour story.
Added dimension right there.
That's an hour story in and of itself, but that hotel is arguably somewhere north of 100 million. Of course, the borrower thinks it's closer to 150 to 200 because they have previous letters of intent from prior. We were hired on that. We were just hired also on the Livingston Hotel to conduct the UCC foreclosure.
Where's the Livingston Hotel?
It's in Brooklyn.
Oh, okay.
So I think hotels. We're working on a note sale of a hotel right now. We're working on a workout or restructuring of a hotel right now. I think over the next few years, it's a very troubled asset class, and COVID obviously took the biggest bite out of the hospitality sector.
Yes.
So we're going to be seeing a lot more of the hotels and the office. Multifamily, again, was just a faction of not getting rents paid. It was unfortunate timing with COVID because it came right on the heels of all of the 2019 rent stabilization changes.
That's right.
So it was a 1-2 punch, and thus values were depleted considerably. I mean, up to anywhere between 10-20% and 40 to 50% on some buildings between the rent stabilization, COVID, and interest rates going from 3 to 6.5. It was kind of the triple whammy, and that's leading to a lot of distress, even in multifamily, which is always regarded as the gold standard and the most stable of asset classes.
Tell me, when a company files bankruptcy or has its building in foreclosure, but there are servicers involved, does that add a level of complexity to the situation?
Yes, in capital letters. I think that the special servicers are very, they're sticklers for collecting every penny. They have, a lot of times with the CMBS loan, they've got bondholders to answer to. And even if we've brought them a phenomenal offer, either to purchase the note or, on the asset altogether, which would cover the principal of the original loan, again, the late fees, the penalties, the default interest, but there needs to be some money held back because typically in those situations, they would need to pay a couple bucks to the broker.
Right.
They also want to save a few dollars off the face or full par because if they get paid back immediately, they would be net negative after legal fees.
Right.
So if they knew that they would have 6 to 12 months of accrued interest, or they weren't looking to, end up with the property themselves on, more of the loan-to-own spectrum, they wouldn't have enough time to be able to build up and make the default interest. So they don't want to get paid off tomorrow and be losing money on that transaction. So even if they
So
say
they
the
turned
servicer-
down the deal? Is that
Correct.
what happens?
Correct. To
Oh.
the special servicer, we can bring 96 cents on the dollar, and I've seen that turned down often because they want 100 cents on the dollar, not making room and not leaving any room for that purchaser of the note to make money if they're paid off tomorrow.
Right.
So they're not willing to offer any discount, and it just adds one more person in the room that, as I mentioned before, when we're shuttling between borrower, senior lender, mezz lender, all the competing factions, actually the borrower, now we're also dealing with the special servicer, and this is in the foreclosure mode. This is not in bankruptcy yet, but it also adds a more institutional level of negotiations with special servicers, and that's happening a lot right now. Once these borrowers have gone into servicing, they're in foreclosure, they don't want to file the bankruptcy, they don't want to have that black mark on their career, they don't want to have potentially a deficiency judgment. When they file a bankruptcy, a lot of times it will trigger the personal guarantees with the bad boy clauses, and that will make them liable down the road, and also makes it very challenging for them to borrow going forward. So
Right.
lenders don't want to lend to someone that's filed a bankruptcy, so they want us to try to help work it out, or again restructure it with the servicer so it can stay in the foreclosure, get worked out in foreclosure mode, and there is no need to file the bankruptcy.
I see. Okay, very good. Well, that concludes our talk today. Thank you, Greg, for joining us. I appreciate the insight, and again, I'm going to borrow that phrase,
Sure.
a giant timeout. That's terrific. And thank you for your time.
My pleasure coming down, and it was great to sit with you in person, and I had a couple takeaways myself, not just verbiage, but some concepts, and grateful to be here.
Well, that's terrific. Thank you.